Recently, I received a telephone call from a client of mine, very concerned as his child had just graduated and was moving towards their freshman year, whether he was going to be obligated to pay some of those college expenses. And the short answer is no. In Georgia, child support cannot be ordered against somebody after the age of their majority. Now remember, in Georgia, child support can continue past their 18th birthday if they're still in school, but once they graduate high school, then you're off the hook. So in Georgia, you cannot be obligated for college expenses unless you have entered into an agreement with your spouse to do so. So during a divorce consultation, we would talk with you, especially if you've got any children that are reaching the age of majority. We would talk to you about how you want to handle college expenses. Ultimately, I do have some clients who agree to pay for college expenses for their children. My advice would be to come in, let me look at your particular case. For most people, I would encourage you not to obligate yourself through a contract to keep up with those expenses after your child has reached the age of majority. Those expenses and obligations cannot be modified by the court. They don't have the jurisdiction to modify if you lose your job or become disabled. So if you agree to cover those college expenses for your child, you will, for all purposes, forever be obligated to do that, regardless of what happens to your job situation or your health or any other factors that may come along. So ultimately, Georgia law does not force you to meet those obligations after your child has reached the age of majority, and Georgia law also does not permit a judge to modify those if you've taken those on voluntarily. So it's a very critical issue for you during your divorce proceedings to look at your facts and circumstances, your children, and whether they're going to be going off to college and incurring those expenses, and really give that careful consideration before you ever obligate yourself to something that a judge could not modify later down the road. Please feel free to give us a call if those are some concerns that you're having as your children reach the age of majority, and we'll be more than happy to walk through your case and decide with you whether that's something that you should do voluntarily or not.